Today we're going to talk about what happens at an Illinois guardianship hearing. So when we talk about guardianship, we're talking about guardianship for disabled adults as opposed to guardianship of minor children. There's two types of guardianship hearings that you can have, two flavors. Uncontested and contested. An uncontested hearing happens when the family all agrees, no third parties object, and the guardian ad litem, who's the attorney appointed by the court to look out for the best interest of the disabled adult, when they're on board with the guardianship too. Everyone agrees that it's in the disabled adult's best interest. You're just getting the court's approval of the guardianship. In an uncontested hearing, the court will review the physician's report, the physician who examined the disabled adult, and they'll review the report from the guardian ad litem, and they might ask a couple questions of the attorney for the proposed guardian, or actually the petitioner, whoever filed the guardianship petition, and basically summarily order in favor of a guardianship. We're going to focus more on contested guardianship hearings because uncontested guardianships are pretty easy. Contested guardianship hearing will be just like any other sort of litigation. The rules of civil procedure apply. So there's going to be pretrial discovery, possibly motion practice, witnesses. Usually there's a physician called for each side, but lay witnesses can testify too. People who are not expert witnesses can testify just based on their observations of the person in question. And basically what the petitioner, the person who's filing for the guardianship, is trying to establish in a contested guardianship is a couple things. One is that the disabled adult is actually disabled and in need of a guardian, and not competent to make whatever class of decisions the guardianship is being asked for. And two, that the person who is the proposed guardian is the right person to be their guardian. And so they have to provide all of the normal evidence that you would in any other trial, except the burden of proof is higher in a guardianship hearing than in typical trials. Typically, the burden of proof is a preponderance of the evidence. So whoever is 51% more likely to have the facts in their favor wins in a typical trial. In a guardianship proceeding, the burden is on the petitioner. The person is seeking to establish that the disabled adult is disabled and that this person should be the guardian. The burden of proof is on them to establish by clear and convincing evidence both of those things. And that's a higher standard of proof than preponderance of the evidence. So a guardianship proceeding, for all intents and purposes, really isn't any different from any other litigation if it's contested. You go through the normal rules of civil procedure, pretrial discovery, motion practice, putting on evidence of witnesses at trial. There can be a jury trial. Both sides, everybody has a right to ask for a jury trial. But typically the only difference is the standard of proof is higher, clear and convincing evidence. And the witnesses, and this isn't different, it's just, something to expect. The witnesses are really, it focuses more on physician testimony rather than lay witnesses, although lay witnesses can certainly testify. The disabled adult is required to attend, but the attendance of the disabled adult can be excused Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. And today we're going to talk about what happens in an Illinois guardianship hearing for a disabled adult. We have some great articles and videos at learn-about-law.com explaining the basics of guardianship and the process for having a guardian appointed. So you should go there for some foundational knowledge. Today we're going to focus on the actual hearing itself and what to expect. There's two types of guardianships. One is an uncontested guardianship. The other is a contested guardianship. pretty self-explanatory, but an uncontested guardianship is when everyone's in agreement that the guardianship is in the best interest of the disabled adult and nobody objects to the person who's being named guardian. And that includes the family, the guardian ad litem, who's an attorney represented to or hired to represent the best interests of the disabled adult appointed by the court, and no third-party objection. So everybody is on the same page. They all think this guardianship is a good thing. And in that case, the court makes some inquiries about the mental state and physical state of the disabled adult, the relationship of the guardian to the disabled adult, and the court will review the physician's report. So the disabled adult will be typically interviewed by a physician to figure out their mental capacity and what sort of guardianship is needed. And the court will also review the guardian ad litem's report. Again, the guardian ad litem will interview basically everybody involved to make sure that this guardianship is in the best interest of the disabled adult. And again, if the reports all agree guardianship is necessary and the proposed guardian is the right person to be the guardian, then the court will just basically enter a summary order in favor of the guardianship. We're going to focus more on contested guardianships. So these are basically situations where either the guardian ad litem doesn't agree with the person who filed the guardianship petition that either a guardianship is necessary or that person is the best person to be guardian, or if there's a family dispute about the necessity of the guardianship, third parties might come in and object, or the disabled adult, him or herself, doesn't agree that a guardianship is necessary or that the person who's proposed as guardian should be the guardian. So these are basically trials like any other trial. The rules of civil procedure apply, so there's going to be pre-trial motions, there's going to be written and oral discovery, maybe depositions taken, just like any other civil litigation case. Learn-about-law.com, we've got lots of articles and videos about the civil litigation process. So if you're curious about the pre-hearing process, you can check that out. At the hearing, one big difference between a typical civil litigation case and a guardianship case is that the standard of proof is higher in a guardianship case than a normal case. So typically the standard of proof is the preponderance of the evidence. So whoever is trying to prove something has to show by 51% likelihood that their version of the facts is more likely than the other person's version of the facts. Clear and convincing evidence is a higher burden, and it's on the person who filed the guardianship petition or was seeking to have the guardianship enacted. And it's basically, it's almost like in government, the difference between a 51% vote in the Senate and a filibuster baiting 2/3 vote. You need to show by more proof than you would in a standard civil litigation case that the guardianship is necessary and the proposed guardian is the right person to be guardian. Usually you will have a battle of the experts if it's a contested guardianship hearing, and this means that two different physicians, one for each side, or if there's multiple people involved, maybe multiple physicians, will have examined the disabled adult and presented and filed reports on whether or not a guardianship is necessary. Now, obviously, if all the physicians agreed that the guardianship was necessary, the hearing probably wouldn't be contested, but you'll have physicians called as expert witnesses to testify the extent of the guardianship that's necessary, and the guardian ad litem will also file a report saying his or her opinion about the best interests of the ward or the disabled adult, and this will all be taken into consideration. The disabled adult is required to attend, but may be excused from attending if either the petitioner can show that the disabled adult is simply refusing to attend, or attendance would be basically harmful to the disabled adult. So the court can excuse the attendance, otherwise the disabled adult should be there. I mentioned physician testimony. You don't need to have expert testimony. You can have lay witnesses, family members, friends, testify about their observations of the disabled adult. So, typically if it's contested, it's better to get physician testimony, but you can lay on top of that a layer of personal testimony from people who know the disabled adult. So at the hearing, both sides will put on evidence, they'll put on their witnesses, and if the petitioner proves by clear and convincing evidence that a guardianship should be ordered and that the petitioner or whoever the petitioner has proposed as guardian should be named guardian, then the court will enter an order basically initiating the guardianship. So let's talk about how a court decides who to name as the guardian. There's a couple different factors that the court will decide. So if a lot of guardianship proceedings deal with, we all agree a guardianship is necessary, but there's two different people who are close to the person and they're vying for who should be guardian, or different factions have arisen within the family. So the court will look at a couple different factors here to determine who is actually going to be the guardian. One is the recommendation of family members. That's given a lot of weight. The relationship between the disabled adult and the guardian is also given a lot of weight. So if the proposed guardian is the person's sibling as opposed to some person who was their friend back in college but hasn't seen them for a couple years, the sibling is more likely to be appointed the guardian. Actions by the disabled adult prior to the disability that basically demonstrate their trust in the person who's proposed to be the guardian. Actions by the proposed guardian that demonstrate concern for the disabled adult's well-being. Another factor is the ability of the proposed guardian to actually manage the estate. So it basically, if the person is an accountant or a financial expert, they're more likely to have the court appoint them as a guardian than someone who has no expertise in that field or who has, filed for bankruptcy a couple of times. Other conflicting responsibilities is another factor. So if the guardian has a conflict of interest based on the responsibilities, or if there are other responsibilities to prevent them from being able to devote the time or the effort or the energy to serve properly, then the court may not choose to have them appointed guardian. Finally, the court will look at the guardian's financial interest in the estate and any impropriety that appears to be there. So, it's terrible, but sometimes people will, when there's a disabled adult, try to be named guardian in order to take advantage and pass finances onto themselves. So the court's going to look at that and make sure that the guardian doesn't have a conflict of interest with respect to the actual funds of the estate, and they're not just trying to take advantage of the disabled person. So once we have a disability established and we have a proposed guardian, the next thing the court will determine is what type of guardianship to award. There's a couple different types of guardianship, and you think of it as a box where it's almost like a rubric, and there's a vertical line and a horizontal line, and on the vertical line is guardian of the person versus guardian of the estate, and on the horizontal line is limited versus plenary guardianship. So there can be a limited guardianship of the estate and a limited guardianship of the person, and a plenary guardianship of the person and a plenary guardianship of the estate. So we're going to take each part of each axis of that line and talk about it separately. So let's talk first about guardianship of the person versus guardianship of the estate. Guardianship of the person is a guardian who's responsible for basically all non-financial matters. So basically making medical decisions for the person, sometimes deciding where the person is going to live, although in a future video we'll talk more detailed restrictions on that. But basically, they're the person in charge of the disabled adult's body and who has access to them. They can even file for a dissolution of marriage. A guardian of the estate has all the financial responsibilities, so financial transactions and some legal transactions as well. So that could often be the same person, but sometimes there will be a different person named as guardian of the person than guardian of the estate. Or sometimes the court will find it necessary to name a guardian of the estate but not name anyone to be guardian of the person because they can make major life choices on their own. They just can't make financial decisions without help. So that's one decision the court has to make, whether both types of guardianship are going to be awarded and if that's going to be split among multiple people. The other axis in the guardianship decision-making process of the court is plenary versus limited guardianship. A plenary guardianship, whether it's a plenary guardianship of the estate or plenary guardianship of the person, means that the guardian has all of the typical powers associated with a guardianship of the person or guardianship of the estate, whichever one we're talking about. So plenary is basically covering all of the typical guardianship powers and duties. Limited guardianship is what it sounds like. This is where the court will carve out certain things that the guardian is responsible for and certain powers and duties that they have, but they're not responsible for the entire financial picture for the person. So in practice, in theory, courts are supposed to only award guardianships for the types of decisions that are absolutely necessary. So in theory, they're supposed to favor limited guardianships and just carve out the decisions that need to be made in certain particular areas and let the disabled adult make the rest of their decisions if they're competent to do so. In practice, it's almost always a plenary guardianship, or basically the full boat guardianship, because it's too difficult. It becomes too difficult to come back to court as the person's condition deteriorates to get more powers or differentiate between the different powers and duties logistically. So usually what we see are plenary guardianships. So at the hearing, though, all of these issues have to be decided. Basically, you have to figure out whether the person's disabled in the first place. If they are disabled, what's the extent of their disability? What decisions do they need help with? What parts of their lives do they need help with? Or do they need help with everything? And then you carve out maybe guardianship of the estate, maybe guardianship of the person should be a different person, maybe they should be the same person. Either way, who is going to have those responsibilities? And that's where the court will look at that series of factors we talked about earlier. And this, in a contested guardianship, this is all proven by evidence, witness testimony, and all of those factors we talked about are what the different sides are trying to prove. So thank you so much for watching and listening. If you'd like, if this was helpful and you're watching on YouTube, please subscribe to our YouTube channel. Please subscribe to our iTunes podcast. Call us at 630-324-6666 to schedule a free consultation. We do a lot of guardianship work. We also do almost every other area of law. And you can go to learn-about-law.com, our website, for videos, podcasts, and articles about nearly every area of law, including a more in-depth article about this podcast and video topic. So thanks so much for listening.